provisions in our regulations. Thank you very much. We have provisions in our regulations for the appointment of experts to assist the court should they need them. Those experts can either be appointed by the court directly or upon a request by the parties. What I don't understand is what makes Sharia as an area of expertise any different from any other area of law that may require the evidence of an expert. For example, I think that if our judges required expert evidence on a piece of foreign law, then of course they would appoint an expert. But whether they accepted his or her evidence would be entirely a matter for the judges. And I think that they would find it quite troubling if there was a provision that said, well, if the expert gives his or her opinion, you are not entitled to reject it, and you will be bound by it when it comes to making your overall judgment. And I was just wondering, what is the justification for treating Sharia as anything different than simply another area of expertise that requires expert evidence?
I think that's a really good point, and that's my view on it. Other than in the Islamic banking and Islamic finance scene, because of Section 56, the courts here, other than in the personal law cases before the Sharia courts of the states, which deal with inheritance and marriages and so on, the courts have actually treated Islamic law as a matter for experts, but ultimately a matter for the courts to decide. And that's how it used to be until Section 56 came in. We've actually had cases not on Islamic finance, but Islamic constitutional law involving issues of administration of Islam, taken up to the Supreme Court, federal court, where the court has actually directed parties to get expert opinion on, for example, in that case, the question was, what is a precept of Islam, for the purpose of interpreting a constitutional provision which allows the states to create offences against precepts. So in that case, 3 expert opinions were obtained, and the court preferred one opinion over the other 2 and gave its reasons. Section 56, I think, is purely about business efficacy, and goes to how it is that I think the regulators perceive the need for some sort of certainty so as to be able to promote their product. But in reaching out to a solution in that way, I think what they've done is undermined the process of dispute resolution, tying the hands of the court and the arbitrator and effectively the parties, because, you know, ultimately what's the benefit of bringing forward opinions if ultimately the arbitrator or the court has to reject those opinions in favor of the SAC? Okay, there's some room for the SAC to be guided by expert opinion, but ultimately there's a policy, I think, that operates within the SAC, or policy framework, that will ultimately shape its decisions, going back to the wider national objective of promoting Islamic finance in Malaysia. So I agree with you. I don't see what the rationale could be other than just efficacy and efficiency and expediency. And I don't think that's a fair consideration to be taken into account when it means jettisoning or sacrificing the entitlement to present a position to the party or the person making the decision. So I agree with that.
Bismillahirrahmanirrahim. I would like to actually respond to the issues that have been raised repeatedly by the person questioning just now. I think, but my view actually is based on what I understand from Section 56 and 57 of the Central Bank of Malaysia Act as a result of the amendment in 2009. Because being a member of the Sharia Advice Council, this issue was brought to our attention. And I think the main purpose of such a section is basically to provide some kind of certainty as to what the Islamic law is on that particular issue. because we have seen Islamic banks in Malaysia operating in a situation where we don't have substantive Islamic law providing for some of the Islamic banking transactions, the that Prophet Andrew said earlier on. So basically, the judges in the courts do not understand those contracts within the meaning of Islamic law. So this was observed from the earlier decided cases, where we have seen in one particular case, the judge, the High Court judge, in the so-called specialized Muamalat court, had decided that the BBA contract was null and void for the pure the reason given was quite anomalous from the Islamic law perspective, because he said that in order to be valid, that transaction must have been approved by all the four mazhab, which is not the case under the Islamic law. So that actually sort of prompted a need for giving some kind of certainty on what is the substantive law on that matter when we don't have a substantive law. So the referral to the SAC under Section 56 was actually purely meant to address the issue of a question of law. In this case, what is the Islamic law position? The SAC is not interested in the question of fact. I think it's perhaps analogous to situations where you refer to the higher court just to determine a question of law rather than determining a question of fact. And that higher court decision would be binding on you as per that question of law. So we are viewing at this issue also similarly. So if you want to know, for example, what makes a valid sale contract or murabaha contract, so the SSC will actually come out with a resolution which is just a question of law, just answering to that question of law, and it's up to the court to apply that to the facts before them and come up with a decision. So the SSC's power does not extend to determine the case. The SSC power is just to give an authoritative view of what is the Islamic law position on that particular contract. So this is the only purpose of that section. I don't know whether it's giving rise to so many issues on the ground, but this is what we have in mind, and in deliberating also this is what we do. So sometimes when the questions frame were given to us, we say this is a question of fact, we are not going to address that. We are going to only address questions of law, and we only give our opinions based on that. So I hope that sort of clarified this issue.
I thank you for that. I think, yes, I understand the rationale, and I think, yes, there's a lot of sense and value in having some sort of standard setting body. Okay, I accept that. And it would be difficult to enact law to cover all the various aspects of Islamic financial transactions. But I think the problem is that the SAC is not a court. It cannot decide matters that arise in the dispute. And I think the question was, if, for example, there was a case about rocket science, you would take an opinion from someone who knew about rocket science, and ultimately the judge would say, I think that opinion makes sense to me, and I will apply it. But here, what's happened is, in the previous form, when it was discretionary for the judge to refer, and the ruling was then something that could be taken into account, that made a lot of sense. Because then the judge could say, well, the SAC, which I view as an authoritative body, and Justice Raus Sharif says that in the Arab-Malaysian case, I think, he says that, well, you've got this body that's given the task of determining and shaping standards or rulings or principle, but there's still some room for the parties to argue their positions based on whatever they might need to argue. And then it's ultimately up to the judge. And that made a lot of sense, and I think it worked for a long time. There was, I think, with the greatest respect, a knee-jerk reaction to the rulings of the High Court striking down the BBA products when two judges said, I think these products are un-Islamic for their own reasons, and they could have said, well, you're wrong. In the Court of Appeal, there is the SAC position, and they could have stopped there. But they went one step further with the new amendments and said, well, now you're bound. And that's where the difficulty is, because we may not agree with what the SAC says, but we're not given an option now to say otherwise. Parties may not agree with the view of the SAC, but the legislation now effectively makes the SAC part of the dispute resolution process on a particular feature that will ultimately shape the outcome. And that's, I think, where the problem is for many of us. But that's a policy question, I guess, for the legislature and government.
It would seem that in the context of an Islamic finance dispute where the seat is in Malaysia, that the choice of law provision becomes very critical, because with seats in Malaysia, you have Section 30 saying Malaysian law, you therefore have, unless otherwise provided, therefore you have Section 56. So would you suggest an adequate choice of law clause that would cover a situation where you could still apply the KLRCA I-Arbitration rules, preserve Rule 11, and yet not have the controversy of Section 56? Would you have a suggestion?
That I think is the crucial question from my point of view, and for me it's of course a little bit difficult to answer it properly. But I think if you look at Rule 11 and you see that there is an element of party autonomy by saying that even if there is no ruling of the Sharia Advisory Council within a certain period of time, then the arbitral tribunal can move ahead and take a decision without a ruling. This is even more than somehow dealing with the with a ruling of the SAC, because it's much more. If you can completely ignore it, why should you not be able to deal with it in a proper manner by applying it to a certain set of facts? I think, and what Malaysia has been trying to do, and the state courts have done that, is to qualify it rightly as an expert opinion. And of course, if a panel who has to take a decision is confronted with an expert opinion, there is still some discretion to deal with it. I have my problems with the term binding. And I think if you look at 56 and 57, the primary issue is the question of ascertainment. So ascertainment is of course something else than making a binding ruling which gives no room for maneuvering any longer. And I think the only area where the law of the land could step in is a question of public policy at the end of the day. Because the public policy issue in enforcing an arbitral award and also enforcing of a foreign judgment or whatever is how it is preserved, let's say the interests of the nations or whatever, and the constitutional rights that may be infringed by a certain decision. But that, I think, is a very, very high threshold. And one would have to put more emphasis on the question of ascertainment, and I fully understand, and I'm very glad to have heard what the initial intention of Bank Negara was, to give certainty. And certain transaction certainty is, of course, a very, very important thing. And for that instance, actually, my reaction would be very strong in drafting a clause in an arbitration agreement for allowing the arbitrators to take a decision ex equo et bono, which, of course, is completely against the interest of a transaction security. Perhaps one little thought of the concept of Med-Arb that you were mentioning also. In Germany, it is clear that a judge, and also our institution, the German Institution for Arbitration, has a similar rule in its arbitration rules, that a judge or an arbitrator is at all stages of the proceedings has a duty to encourage the parties to settle their dispute. And of course, that is a concept with which you are in the common law arena are not familiar at all. But I think this is gaining a lot of momentum. And how is that in practice done? It is done in a manner that at a right point of time, an arbitral tribunal would give some preliminary assessment of the legal aspects of the case, some preliminary views on where the risks and problems in the evidentiary process are, and then do exactly what you do, tell the parties, look, these are the risks, now reconsider your positions and see whether you can find terms, and if you don't, we will decide. And very often this clarification helps a lot in coming to a resolution of the dispute. The question is when you do it and how you do it. And so far we have had very good experiences with that in our part of the world, and that is nothing particularly Islamic. I think that is very useful and practiced all over the world.
Thank you. Are there any further questions? Yes.
Under Rule 11, I think Thomas was talking about this earlier, but if a Sharia issue is identified and it is referred to the Sharia Council, to what extent is the ruling binding upon the arbitral tribunal?
I think it is binding to. I would not accept the term binding in that context at all, because binding, of course, suggests that you don't have any discretion any longer. And if you say, look, the Sharia Advisory Council has decided to deal with that in that and that manner, and you would not be able to escape it, and it would at the end of the day result in you as an arbitral tribunal or a sole arbitrator just not applying your own perception of it, it may be the same. You may come to the same conclusion, but you must retain the freedom to really apply the ruling to the set of facts before you, and you have to evaluate it properly. I would not say that, and I would not like the relation of a court of appeal giving a binding and sending things back. We don't have the doctrine of precedent in my home jurisdiction, so any judge is at all times free even to ignore a decision of our Federal Supreme Court. This may be difficult in his further career to some extent if he tends to ignore a judgment of the Federal Supreme Court, but in principle he has the liberty to form his own view, and I think that would be the proper advice. I think an award where an arbitrator would simply follow what the Sharia Advisory Council has said would have problems on the enforcement level, because the transfer of the decision-making power to a body to which the parties have not agreed. Although, of course, there may be an argument that having accepted the whole dispute resolution process, the parties have somehow waived that argument. So there is also something that you could use it from a different perspective, but still that would give it very much uncertainty.
Just one more question, yeah.
Hello. I was thinking about the problem facing by Mr. Malik Imtiaz in the referral under Section 56 of the Central Banking of Malaysia Act. Wouldn't be, I mean, just my suggestion, wouldn't be a rewording of Section 56 along these lines help, which is the High Court judge must refer any questions of Sharia law to be arbitrated before the SAC instead. Given that the SAC has expertise on this issue, and then of course there's a problem about a right to a fair hearing, parties can't present their own case, well, why can't it be arbitrated before the SAC? And let the SAC hear from both parties, and then there will be no issue about enforceability, because Section 56 binds the High Court. I suppose the main weakness of this argument is that parties can choose their own arbitrator tribunal, but certainly it would ventilate some of the problems facing right to fair hearing. Wouldn't that be a viable alternative? Thank you.
Thank you for the suggestion. If I just may share my own experience on this issue, I've mentioned regarding what I've highlighted to the Law Harmonization Committee of Bangara. That is where how they eventually decided that they will come up with a guideline on how to submit the questions to the SEC. Yeah. From all my conversation with other with SEC members whom I know, they are actually very reluctant to play this role. Yeah, they are, like Malik said, you know, they are not judges. They are not used to being judges. Yeah, if people ask them a question, because they are mainly professors in the universities, maybe some of them, although they are judges in the Sharia court, but they mainly deal with family disputes. So they are reluctant to play the role of arbitrating or judging. That's why Prof. Kurabia, I think, has explained very carefully that they would not want to deal with facts. They just will address the question of law. Yeah. So maybe, as far as your suggestion is concerned, my view is that it may be expedient to the parties who are disputing, yeah, because they want the dispute to be heard before the most competent arbitrator. But you have a problem here of the fact that the arbitrators themselves are reluctant to play that role. Most of the Sharia scholars that I am aware of, they are not very keen, to openly sell, so to speak, sell their service to resolve your issues. If you have an issue, you come to them, they will try to help. But they don't like the obligation of having to help, yeah. Especially if it is very specific or just privately your issues with vested interest, yeah. So the way the Sharia Advisory Council has worked since it was first incepted in 1997 has always been assisting the Bank Negara to come up with policy decisions. They have never been actually trained, or exposed to being judges or arbitrators in actual financial disputes, which is why even when the proposal was made to amend the Central Bank Act and make this decision binding, it was decided from that very narrow perspective of trying to resolve the BBA problem, And when we talk about the BBA problem, I mean the Bank Islamic Ajil contract that has raised a lot of disputes in the context of Islamic finance practice in Malaysia, it is a serious issue as far as Malaysia is concerned, because for many banks, maybe 90% of their portfolio is actually in BBA. That's why the need for expedience, for the need for urgency, the need for certainty in the Sharia issue as far as Bayat Islamic Ajil is concerned is very serious at that point of time, yeah. Because it seems as far as the market or the industry is concerned at that time, they are not comfortable with the way some of the judges in the High Court seems to make their decision, especially in the case of M Finance and M Finance and versus Taman Ehsan Jaya, whereby the way the judge made that decision was very unprecedented. He basically called all the lawyers who have BBA disputes to come before him, make written submission. I will make this single decision for all 12 cases. So no proper hearing, no calling of experts opinion to provide view. So and because he even made that or took that position that as far as Islamic law is concerned, under the legal framework in Malaysia, Islamic law is part and parcel of the law of the land, and judges are supposed to know the Islamic law because it is law of the land. They don't need, or they are not supposed to call expert evidence for something that they are supposed to know. So this was the whole background behind that case, which really made the whole industry nervous. Yeah. So to this extent, it may be a peculiar case only for Malaysia. I wouldn't say the same for other countries which has Islamic banking practice. But it is quite peculiar to Malaysia at that point of time, and on this particular issue, and this was the decision that probably was a reaction to that, and we have to consider the fact that it was trying to it was an attempt to address certain concerns, but not without any unintended consequences. So that's the learning curve.
I just want to clarify a bit on this issue of bindingness, which was alluded to by, I couldn't get your name, sorry, Dr. Thomas. Okay, because my understanding of the bindingness is just, it's not on the decision making. It's more of the law, of the legal position. Okay, so let's say, for example, if the SAC made a resolution that Ba'al-Ina, for example, is permissible, then the judge, the court, cannot say that Ba'al-Ina is not permissible. This is what I mean by binding. But as to the facts before the judge can still have the discretion to see whether this transaction actually complies with the rules of Ba'alina or not. And he may actually come to the conclusion that although Ba'alina is allowed by the SAC and is permissible, but the way the parties transacted it is not compliant with some of the rules under Ba'alina, therefore it is still not valid. So that is the discretion left to the court. So what the SAC is trying to say is, we are just stating the law, the Islamic law, and this statement of Islamic law, because the certainty is because there are many different opinions. There are some other mazhab who say this is not permissible. So we don't want the court to opt for that one. Basically, we want to say when SAC says this is permissible, this is what the law is, at least in Malaysia. But how you apply it to the facts is totally at the discretion of the judge. And this actually brings me to the second point. It is not the SSC's intention to take the role of a judge, to hear and listen to the parties, and this will not be constitutional anyway. It will be challenged constitutionally that we are not part of the court system. Okay, the whole thing that the SSC wants to do is just to state what is the Islamic law position on this contract as something which is quite academic, where you actually put it into the facts. This is up to the court how they're going to decide. And for that purpose as well, Section 56 is, to me, is quite temporary in the sense that how you're going to refer to the SAC, and SAC here means firstly the SAC rulings and resolutions, and moving forward, based on Section 29, I think of 28 or 29 of the IFSA, Islamic Financial Services Act, we have now Sharia standards being going to be issued by the central bank. So moving forward, that referral means that the court will have to refer to these standards. So just like you say, you refer to certain statutes, that is the law. So you don't have to refer specifically to the SAC, because they have actually proposals from the industry that this is their main job to actually look at, and not the court cases, but because they make rulings on the products. Okay, so they just want to just reinstate what is the ruling in terms of the Islamic law position. Just that we are not going to decide the case. Please be certain about it. We're not interested to decide the case. It's not our job. Okay, so there's no issue of parties presenting before the SAC. I don't think that is the job for SAC. So moving forward, we foresee that we just look at the Sharia standards just like you look at any other enactments or law, and it's up to you how to interpret those standards. Okay.
Thank you, Professor. I understand that we have one final question. It has to be very quick, I'm afraid, because we are running very late.
Okay. Sorry, just a really quick one. Can I just get the panel's view on a hypothetical situation? And what Professor Andrew White said just now is sometimes when you have the better set of lawyers, they kind of know what to do and which experts to engage in, etc. So, and Datuk Malik, if you could give your views on this. So what if we have a situation where we have, let's say, a non-Muslim judge hearing this dispute who has no background at all on Sharia? So we start off with that, and both parties are allowed to bring in their expert reports on this particular Sharia question. And let's say you get the better set of lawyers who have engaged or could afford to hire an expert who maybe was more articulate, had a better report, and on that basis you have this judge that forms an opinion. Okay, I'm going to take this particular person's expert opinion based on that. Does that not mean that we are letting this judge who doesn't have background knowledge or anything, right, on this particular Sharia question, decided based on that expert opinion, but that expert opinion still might not be what's right? So what happens then? That's my question. What are your views on that hypothetical situation? I'd like to know. I'm a practitioner, and I'm very interested to hear what you all think about this.
But doesn't that happen in any case, on any subject? Whether it's shipping or insurance or whatever, it's part of the adversarial process. So
sure.
if you're saying that this subject should be treated differently, because it's Islamic banking, then I think there has to be rethinking about what sort of mechanism we want to have these sorts of, for example, a court that's specially established just for Islamic banking with judges who are trained, etc. And I think maybe that's what's needed. But until that's done, and looking at the way in which the framework is placed currently, that's it. I mean, there are judges. There are judges in other states. I think in KL we have specialized, more specialized Islamic banking courts. Judges are dedicated to that. But if you go out to Penang or wherever, judges are hearing everything, including disputes involving Islamic banking. Precisely, but don't you think then that because the situation is like that now, where we don't have an Islamic Contract Act, or we don't have, certain other codified acts which, govern Islamic financing transactions, don't you think that that's why, at this particular moment, given that lacuna, SAC is there? Okay, I think the fact that standards are being issued, that makes sense. I'm not sure about constitutionality of that, but the fact that Bank Negara is empowered to say, okay, this is how you view products of this nature, that makes sense to me. And you've not heard anyone say that the rulings should be ignored. What we are having a problem with is this reference. So I think perhaps there shouldn't be reference. There should be just standards issued by Bank Negara's SAC without the need for reference. How that happens, I think you can leave that to work itself out. But the moment you say that there's an obligation on the dispute, the arbitrator or the court to refer it becomes problematic because of all the things that we've been saying. I think so.
Okay. Yes, I'm afraid I have to call it a day with that. Thank you very much for all the questions, and thank you.